Hello, everyone. Hello, YouTube. Hi, everybody. If you happen to be on YouTube right now, come on in and say hello. I'll give it some minutes before I start on what I want to talk about this afternoon. I hope everyone has had a great day so far. It is still very hot in Alabama. We are dealing with a lot of heat, and it is what it is. How's your day going? Come on in, come on in, come on in. Let me know how your day has been so far. And if you have questions that I can answer real quick, put them in the comment section and I will do the best I can to answer them. Keeping in mind, my answers are general in nature. So if you need anything specific to your case, then we would need to set up a proper consultation for you. So, and once you come on, say hello, put your name in the comment section. Let me know you're on because I can see people coming on, but I cannot tell who it is. And I appreciate everybody who has subscribed to our YouTube channel. And if you know anyone else who will be interested or who will benefit from all this immigration information, invite them to subscribe. Click the subscribe button on our YouTube channel. Invite your friends and families to subscribe, and we really appreciate that a whole lot. So I wanted to come on real quick and talk about going from a 2-year green card to a 10-year abuse-based green card. Going from a 2-year green card to a 10-year abuse-based green card. So let me correct that because I see edit there. Yeah, I wear glasses. So I see instead of card, it says cared. Yeah, I wear glasses, but I use glasses, I just don't wear. Makes sense? Okay, there we go. Correction. So for those who don't know, this is Attorney Efisola Ole Samuel. I am an immigration lawyer based in Alabama. But if you have an immigration case that my firm handles and we decide to take your case, I can and I do represent immigration clients regardless of the state you live in. So like this month, I'm heading to Minnesota. And then next month, I'm heading to Chicago. I'm heading to Salt Lake, Utah. I'm heading to Texas in October. It's immigration practice. Immigrants live in different states, right? And if an attorney is licensed in one state, they can represent you regardless of the state you live in. So don't let that be a deterrent to you deciding that you want an attorney in your case. Let's jump right in. 2-year green card to 10-year abuse-based green card. Basically, what that is you filing your I-751 petition because you are currently a conditional resident and you are granted conditional residency status if at the time of your application, at the time your application is approved, your marriage to your green card holder or citizen spouse is under 2 years. If it's under 2 years, you will be granted conditional resident status. And then 2 years from then, you have to file the 751 to apply for the 10-year green card. And in the 751, one of the main requirements is you have to file jointly with your spouse. If you don't file jointly with your spouse, you have to request a waiver of that joint filing. One of the grounds of waiver, or one of the waiver grounds, is abuse-based. So let me say this at this point. I have a lot of questions that come in and people say, okay, so does that mean if I can't file with my spouse, then I can file a VAWA case? No. There's no reason. First of all, filing a VAWA case is for people filing VAWA is for people who don't have a green card at all. 751, you have a green card, you're trying to go from a 2-year one to a 10-year one. So VAWA is not an option because you already have a status. But the element of VAWA, the main element of VAWA, which is abuse, is already an option for you when you ask for a waiver-based 751 petition. And that's because extreme cruelty, physical abuse, or extreme cruelty is a waiver ground when it comes to a 751 petition. The same evidence you would need in a VAW case is the same evidence you would need to substantiate your 751 petition abuse waiver ground. So when you know that you are qualified and eligible for the waiver ground of abuse, then you want to make sure you have enough evidence to support the fact that you have suffered abuse at the hands of your spouse. And based on that, you are asking USCIS to exempt you from the joint filing requirement requiring you to file with your spouse. How do you now prove that extreme cruelty or physical abuse? Physical abuse is very straightforward. But before you get to the abuse base, keep it in mind that when you're going from a 2-year green card to a 10-year abuse-based green card, you still have to show that your marriage was in good faith. So you have the burden to show that you married that person for real. The intention was to commingle and do life together. But because of this abuse that they have done, now you've suffered at their hands, that marriage can no longer continue. And so you would have to show the basis of why it can continue. You have to show the good faith part, that marriage is real. You commingled life, bank statement, lease agreement, having a child, all that goes to show life together. Once you've established that first element, that first prong, next prong is to be able to substantiate that you suffered either physical abuse or emotional, verbal, financial, sexual, whatever other things will fall under extreme cruelty definition. Physical abuse can be injury, photos of injury, police report, police incident, black eye, damage to your property, damage to whatever the case may be that you can have physical evidence of. In most cases, especially because we're dealing with immigrants, I represent a lot of Africans. Where we're from, we're not raised to go talk to the police officer or authorities about your life. So a lot of times people don't go to police stations or make a police report because, first of all, there's a thing of shame. Secondly, you're raised in a culture where you keep things on the wrap, right? So in that situation, it's hard to even have any evidence of physical abuse. But that's where declaration comes into play. That's where you see having the psychological evaluation comes into play. That's where you see a therapist comes into play. Affidavits from friends who you talked to about the issues you were having. Affidavits from people who knew or who know your spouse and know of their valid nature. Anything that helps substantiate that you did in fact suffer abuse, that will make you qualify to. Hi, Mr. Sin. How are you? Give me 1 second. I'll get to your question. That will make you qualify for the abuse-based waiver ground requirement. So, making sure, obviously, to know every case is different. The facts of each case are different. What evidence will apply to your case is different from the evidence that will apply to your neighbor's case. The best thing for you, before you even embark on a waiver-based, abuse-based waiver 751 petition, consult with an immigration attorney. Know what your rights are, know what your options are, so that you can increase your chances and help your case and try to avoid a rejection or a denial altogether. So that would be what I would suggest, say, it doesn't have to be me, but just consult with someone who knows what they're doing, who has an eye for what they have done, has the experience, and can tell you that based on your narrative, this is what we're going to need to substantiate your case. One of the things I do the most in my firm, I would take an I-751 case. I have no problem doing that. But most of my I-751 petitions are abuse-based grounds. And that's because, and most of them are people, from India, from West Africa, from those cultures where can relate to reasons why we don't have police reports. So best thing you can do is to consult and make sure your case is strong from the word go. If you need our help, my information is scrolling across the screen. Name, you already know my name, but it's scrolling across the screen. Number here is 334-341-4475. Email is aos@oalawfirm.com. Website is, let me put that back up. That's a website, oalawfirm.com. So you can contact us and we can help you with your case and evaluate your case and help you. So let's see what Mr. Singh says. I have pending since November 2019. I received 3 prima facie, but petition is still pending. So your petition may still be pending because your petition is still within normal processing times. And I always tell people, especially for those starting VAWA fresh, like VAWA is taking anywhere from 18 months to 2.5 years. There's a lot of backlog, so you have to be completely patient. But right now, it's a lot. If you go on uscis.gov/processing times, you would see that they're working on cases received in June 2019. So, Mr. Singh, if you submitted your case in November 2019, then they're still working on your case is still within normal processing time. You calling and making an inquiry right now is just going to have them pull your case, and then they're going to see that it's still within normal processing time, and then it doesn't necessarily go back to the place in queue and put you back where you were. You risk pulling yourself even further back. Now, when they start working on cases received in November 2019, then you can start making inquiries because you'll be within your right to start doing that at that time. Hello, Miss Esther. How are you? I have a pending VAWA case in September 2019. Got a work permit. I'm going to renew the second one, but never got a prima facie. Is that a good sign? Now, I'm not going to sit here and tell you that all the VAWA cases that I filed, I've gotten prima facie determinations on them. No, I have not. Have I gotten approvals on those that I never got prima facie determinations on? Yes. Have I gotten a notice of intent to deny on those that I got prima facie determination on? Yes. So prima facie is just basically, we've looked at your case on an initial review basis. If we were to approve this case as is, based on what we're looking at, it's approvable. So prima facie is all just a pre-approval. Just like you get a loan for a home, right? You go to a company and they give you a pre-approval letter because they take your initial information, and based on initial information, they say, okay, based on what you've told us, we believe that you will qualify for a loan. Then the bank goes further and starts to do the credit check and verify your employment and verify this and verify that, get you an appraisal and all that, and then make a decision whether they actually are going to approve that loan amount for you. The fact that they gave you a pre-approval letter does not mean the bank is going to give you the loan. That's basically a prima facie determination in a nutshell. But the fact that they don't give you a pre-approval letter does not mean they won't give you the loan. I hope that explains that. So, but right now your case was filed, you said in September. So they haven't gotten to September yet. They're still working on cases received back in June 2019. So thanks to all those who jumped on. If you need our help, once again, this is Attorney Abisola Ole Samuel, immigration lawyer based in Alabama, representing immigration clients in all 50 states. Thank you. And please subscribe. Invite your friends to subscribe. And until next time, everyone on YouTube. And if you want to, another thing is, if you subscribe, you will be able to get a notification when I'm live, and when next, sometimes I would put a reel up and say I'll be live, so and so day, so you know exactly when to come on. And I have lots and lots of videos on my channel as well that you can scroll through. A lot of people tell me, hey, listen, I was not sure about this. I saw a video you did and that answered my question. So it's good, subscribe. Browse out the videos on our channel, and if you need more help with your case, you know how to contact us. Until next time, bye-bye.